The Notice of Deficiency is the IRS's "Now It's Serious" letter. You usually see it after you ignore a 30-day letter or you go to appeals and still can't agree. It's a formal legal notice sent by certified or registered mail, and it's the key that unlocks tax court. On the EA exam, remember, no notice of deficiency, generally no tax court for a deficiency case. Here's the big rule. The IRS must issue a notice of deficiency before it assesses the deficiency, and the taxpayer must file a tax court petition within the deadline measured from the date on the notice. This is why people call it the 90-day letter. It's not a suggestion. It's a hard gatekeeper for tax court access, and the exam loves deadline questions. Now calculate the petition window. If the notice is addressed to a taxpayer inside the United States, you get 90 days from the date of the notice to file the petition. If it's addressed to a taxpayer outside the United States, you get 150 days. Notice what controls: the address on the notice. On exam questions, they'll sneak in foreign address to trigger 150 days. What happens if you file on time? The case is docketed in tax court, which stops the IRS from assessing that deficiency while the case is pending. Then, in real life, the file usually goes back to IRS appeals to see if it can be settled without trial. That's not just trivia. Most tax court cases settle before a courtroom hearing. The exam angle, timely petition, preserves your forum. Miss the deadline and the door slams shut. If no petition is filed in time, the IRS can make the final assessment and start collection. And you can't use tax court to fight that deficiency anymore. That's why the 90-day letter is such a big deal. Tax court is the one place you can generally contest the tax before paying it. Blow the deadline, and you're usually in pay and sue for refund territory instead. Quick examples. Maddox gets a notice of deficiency dated March 30th. If he wants tax court, he must petition within 90 days of that date. If he petitions on May 1st, he's fine, timely, and the case can be worked in appeals again. Now Angela lives in Panama, and the notice is mailed to her Panama address. That's the foreign address trigger, so she gets 150 days to petition. Marcus was audited, and the IRS disallowed a large business deduction. He went to U.S. tax court and won. He hired a lawyer to file the petition and paid court filing fees. Can Marcus recover the legal expenses he incurred to defend his position? The choices range from yes, but only if certain requirements are met, to no reimbursement at all. Think about it. The best answer is yes, but only if the court agrees with the taxpayer on most issues and finds the IRS position unjustified. A prevailing taxpayer may be awarded reasonable litigation and administrative costs, including attorney's fees and court costs, if statutory requirements are met. The tempting wrong answer is no reimbursement, because that's common in everyday life, but tax law allows cost awards in qualifying cases. A case in the U.S. tax court is commenced by what action? The options include an IRS impasse, a formal protest, the filing of a petition, or a taxpayer's appeal. On the EA exam, they want the exact procedural trigger. Think about it. The correct answer is the filing of a petition. A tax court case starts when the taxpayer files a petition with the tax court, generally after receiving a statutory notice like a notice of deficiency, and it has to be filed within the 90 or 150-day window. A formal protest is part of the IRS administrative process, not what begins a court case.